Hi friends, welcome to SNCA Study Club, a platform for CA final students.
So, my dear friends, here I am providing you certain question from the chapter Prevention of Oppression and Mismanagement that has been asked in the previous attempt, and that is provided in the mock test papers and compilers, etc. So the first question is ABC. There is a private limited company ABC. There is having what? 8 members. There is having what? 8 members. Can a member holding less than 1/10 of share capital file application under section 241? So first of all, we have to explain what is provided in section 241. 241 of Companies Act 2013 provides for application filing with tribunal by the members or by central government. So who are eligible to file application under section 241 is provided under section 244 of Companies Act 2013. So here is section 244 of Companies Act 2013, which is mainly classifying the companies on the basis of companies having share capital and company that is not having share capital. In case if it is a company having share capital, such an application shall be filed by the members, that is 100 members or 1/10 of total number of members. 100 members or 1/10 of total number of members. Here there is not having 100 member, there is only having what? 8 members. So 1/10 of 8 member means 0.8, right friends? Or members holding 1/10 of issued share capital. So share capital condition is additional to the number condition. Here we have know that the application can be filed by 100 members or 1/10 of total number of members. 1/10 of total number of members means 8 into 10%, that is 0.8. That is even one person can file application, right friends? So here what is happening? ABC Private Limited Company having total 8 members and irrespective of the fact, irrespective of holding of equity share capital, one member can present the petition to tribunal. That is, as per this case, 1.10 of total number of member is 8. Total number of member is 8. 1/10 means 0.8, that is one person. So here what is the final conclusion? One member can present the petition to tribunal regardless holding share capital, right friends? I hope you have understand. This is an important question that have been asked in previous attempt. Hello my dear friends, here I am discussing another questions from the chapter Prevention of Oppression and Mismanagement. So here what is happening? There is a company known as XYZ Limited. What? XYZ Limited Company, and members of that company, around members holding 12% of issued share capital, filed an application with tribunal under section 241 of Companies Act 2013, and the reason was majority of members of the company was oppressive towards minority. So what happened? Members holding 12% of issued share capital filed application with tribunal for the purpose of relief from oppression and mismanagement. And later what happened? After filing of that application, members holding 5% of issued share capital withdrawn their consent. So only remaining members, but 7%, members holding 7% of issued share capital is again supporting the application or petition that has been filed under section 241. So whether it will affect the maintainability, that is the question. So in this case, first of all, you have to explain section 244. What is provided in section 244? First of all, it is classifying the company on the basis of share capital, company having share capital, not having share capital. In case if the company having share capital, the eligible members means 100 members or 1/10 of total number of member, or members holding 10% of issued share capital. Sorry, 1/10 of issued share capital, right friends? So here 12% of members holding 12% of issued share capital has supported the application, or they filed the application with the tribunal. But later what happened? They withdrawn their consent. So here you can quote a case law. Rajamudri Electric Corporation versus Nageshwar Rao, where Supreme Court stated that subsequent withdrawal of consent will not affect the maintainability of petition. Members consenting at the time of filing of application or petition is considered to determine whether it is required to accept the application under section 241 or not. So it stated that subsequent withdrawal of consent will not affect what? Maintainability of petition. Case law. In case if you wish, you can quote the case law Rajamudri Electric Corporation versus Nageshwar Rao. Okay friends. Hey friends, here it is one more question which is about the same type of question, but they have difference. Here in the previous two questions we have not discussed why they filed application. In this question it has been clarified that why the members filed application with the tribunal under section 241. So here what is happening, there is a company and this company is having total 300 members. Out of these 300 members, 25 members have filed application with tribunal under section 241 of Companies Act 2013, and the reason was continuous losses that has been incurred by the company, and due to these continuous losses company is not declaring any dividend. So here out of 300 members, 25 members has filed application, and these 25 members holding 10% of paid up share capital, which is equal to 1/15th of issued share capital. So is this application is valid one? That is the question. So like the previous question, first of all you have to describe or explain section 244, which is mainly classifying company having share capital and non having share capital. In case if it is a company having share capital, such an application under section 241 shall be filed by either 100 members or members 1/10 of total number of members. Here 100 members not filed the application, only 25 members. Whether this 25 equal to 1/10 of total number of members? No, because total number of members is 300, 1/10 of total number of members means 30 or 100, whichever is lower. Here 30 is the criteria, but only 25 members filed the application. And the second one, members holding 1/10 of issued share capital. Here what is happening, they are holding 1/10 of paid up share capital, which is equal to 1/15th of issued share capital. So the second condition is also not satisfied by the company, right friends? And the last one that we have to check is the reason why they filed such application. It is because of continuous loss and non-declaration of dividend, and continuous loss and non-declaration of dividend is not amounts to oppression. So the application that has been filed by the company's members are not tenable. Okay friends. So here it is another important question. The question is MNC company having issued share capital and paid up share capital of 5 crore consisting of 5 lakh shares of rupees 100. So what is happening here? The members of the company, they have total 500 members. The members of the company has filed application under section 241. Under section 241 for what? Relief of oppression or mismanagement, with whom they filed application with the tribunal. So total number of members 500, but the members who supported the application is 80 members. So the question is the action or is the act which has been done by the company is eligible, or whether the company is eligible, whether the company and its members are eligible to file application under section 241. So we know that whether they are eligible to file application under 241 is provided under section 244. So first of all you have to explain section 244. Section 244 provides that, or it is mainly classifying the company on the basis of company having share capital, company not having share capital. In case if it is a company which is not having share capital, at least 1/5 of total number of members is required to file such application. And in case if it is a company having share capital, then such application under section 241, what application under section 241 can be filed by members, either 100 members or 1/10 of total number of members, whichever is lower. And in case if they fails to fulfill the criteria on the basis of number, then they can consider issued share capital, that is 1/10 of issued share capital, members holding 1/10 of issued share capital. So Now you have to explain the present case. What is happening? MNC company having 500 members holding MNC company having 500 members having share capital of 5 crore consisting of 5 lakh shares of rupees 100, and application under section 241 has filed by 80 members holding 1 lakh shares. So here what is happening? Total number of members is 500, 1/10 of 500. Either 100 members or 1/10 of 500. 1/10 of 500 means 50 members. So here applicants are 80. Total number of applicants who has filed application under section 241 is 80, which is more than 50. Right, friends? 80 is more than 50. So the act of filing of application under section 241, which has been made by MNC company and its members are eligible, or the members are eligible to file application under section 241. That is the essence of this question.